You have resigned from your current job, you are waiting for your final settlement, you ask the same with the HR or the company, and the company gives you the standard answer that it will require around 45 to 60 days to clear your final settlement. Now, you must have heard this kind of situation, or you must have faced this kind of situation earlier if you have ever resigned or maybe get fired from any job, or if the company has laid you off, or even the company has shut it down its all operations. In all these scenarios, company will say the same thing, that we'll get back to you and will clear your FNF in 60 days. But recently, something interesting is happening in India. There are new labor laws that are passed in India, and you must have heard about it also. Now, the new law gives an interesting timeline for this final settlement, and that's basically just 2 days or 48 hours. Now, the new law says that if employee is leaving your organization or the company, then it is the duty of the company to settle his final amount within just 2 working days, or like maximum 48 hours. But here's the important thing: not every payment is covered under this 2-day rule. So I'll break it down what exactly this 2-day rule for you, and what you can do if the company is not paying you your final settlement within this period. We'll explore the legal options also in this video, so stay with me. Also, I wish to give you a basic disclaimer that labor codes, even though they have passed by the government, still they are not applicable in whole of India. So sometimes maybe you need to see if your state has enforced, or like if your state is using these laws or not. Now, what is this 2-day rule? So first of all, we'll discuss to whom exactly this 2-day rule applies. So the application is quite clear, that even if you have resigned from your job, or you got fired by the company, or you got laid off by the company, or even the company had shut down its operations entirely in this organization, still you are liable for these 2 days of like final settlement period. So that rule completely applies to you. Now, here's the most important thing that many employees may miss. So the law clearly, or the rule clearly says that the company has to pay your wages. Now, the definition of wages is also given in the act itself. And the wages does not contain the everything that the company owes to you, and it will basically contain your basic salary, your dearness allowance, and the retaining allowance only. So if the company has pending these kind of amounts to you, the company has to settle all these three amounts within the 2 working days only. But the definition of wage does not include your gratuity or your statutory bonuses or other compensations that company is giving to you. So does that mean that you cannot get, or you will not get this kind of money from the company for these items specifically? So the answer is no, it's not like that. It's just that these kind of money that you will get from the company will follow the different timeline from your salary. So if your basic salary is there, then company has to pay that salary within the 2 working days. But on the other hand, if the gratuity is there, then company has actually 30 days of timeline to pay your gratuity. So that's the basic difference. You can basically remember it as your basic salary plus your dearness allowance and your retaining allowance. Company has to pay these amounts within the 2 working days only. The rest of the other amounts will follow different timelines, and that's it. Now, the next question is, what exactly is included in your final settlement? So your final settlement shall consist of following items for sure. So firstly, your unpaid salary. So how many days you have worked with company, then company has to calculate all those days, and company has to pay for all these days salary to you in your final settlement. The second thing is your leave encashment. So if you have worked with the company and you have earned lots of leaves also, you have not used them, then company has to pay for that leaves. Now the next thing that shall be included in your final settlement is your statutory benefits. This will include your PF and your gratuity. So basically, if you have worked with any company for, let's say, 5+ years, then that company has to pay gratuity to you. Also, there's a big change in this gratuity thing with this new labor code. So if you are working on a fixed term contract with any company and you have completed 1 year with this company, then you are also liable or eligible for this gratuity from this company. This is actually quite good step towards the peoples who are like working in a fixed term contract. So the next thing that shall be included in your final settlement is the deduction. So the TDS shall be there if you are like getting the salary. Plus, if you have left your job without serving the complete notice period, then company can recover that amount from your final settlement also, provided your employment contract or your appointment letter must say so. Now, the two questions that almost every employee asks. The first is, what documents shall I ask to the company? And the second is, what happens to my PF? Regarding the documents, then don't just accept the salary in your bank account, but you have to see the calculations that company did. You need to see if the numbers are matching or not. If they are not, then you can raise concerns over it also. Now, following are the most important documents that you should definitely ask to the company. Firstly, a detailed calculation of your final settlement, then your relieving letter, then your experience certificate, and the no due certificate showing that you don't owe anything to the company hereinafter. So actually these documents will save lots of your future trouble if you are at all planning to join any new company in the future. So now regarding your PF, once you stop the employment, then that employer or that company stop paying your PF account. And once you join the new company, then basically that company will start paying a new PF according to your new salary. Now, one of the most important and practical questions of this video: what happens if the company is delaying your final settlement and is not paying your salary on time? So the first option is sending an email to your HR. So you have to send email to your HR stating that your salary is pending and there is no FNF has happened, and you can ask for a deadline also. And if you want, you can also mention this 2-day rule of a new labor codes in your email. So basically this will create a kind of evidence from your side to the company that you have given your notice to the company regarding your pending salary, and this will be a really good proof for your future things that you will do if this company is not paying your salary on time. So the second option is sending a legal notice from a lawyer. So if the company or the HR has stopped answering to your messages or your emails entirely, then you have to consult a lawyer and send a legal notice to the company stating that your final settlement still has not happened and the company owes the amount and all those things. Also, if the company is not paying your final settlement, then that will also attract some kind of penalty on the company also. Therefore, if you will consult a lawyer and send a legal notice to the company, then most likely that issue is going to resolve on that spot itself. So now the third option is to file a complaint with the labor commissioner. If your company or HR is not at all responding, and even if they are not responding to the legal notice that you have sent via lawyer, if still they are not responding, then you have to file a complaint with the labor commissioner only. And once you file the complaint, then those things will move forward fastly, and most likely at this stage the matter will get resolved for sure. Now before I end this video, a pro tip for you if you are resigning from any company. So basically all the documents that you will receive regarding your employment will always be on your office emails. And this will include your offer letter, your appointment letter, maybe your employment contract also, then your salary slips or your attendance sheet or any other document which is related to your employment. You should take copies of all those emails or forward them directly to your personal email, because once you will stop working with this company or after your last working days, you will not get access to these kind of documents thereafter, and it will be really difficult for you to get these kind of information again from the company. If you are waiting for your final settlement, you can definitely comment down and let me know at what stage you are right now, and are you facing any problem in your getting your final settlement with the company. Until then, this is Akshay. Read before you sign, and I'll see you in the next video.